one of the biggest missteps by the Alec Murdaugh defense team in this murder trial is opening the door to the roadside shooting. And if you don't know what that is, Alec Murdaugh is accused of killing his wife and son back in June of 2021. He shot them to death. That's what he's accused of. In September of 2021, Alec Murdaugh himself was shot in the head while he was driving. It was a roadside shooting. He went to the hospital. He survived it. Come to find out, and he admitted this to police, that he actually organized the roadside shooting. And he organized it through a guy named Cousin Eddie, who was his drug dealer. What's really come out in this trial is that Alec Murdaugh has been embezzling and defrauding his law firm for years, clients and the law firm, of millions and millions, probably in the 8 figures, not 7 figures, 8 figures. And the explanation for all this money is that he has a $50,000 a week drug habit. He was using Cousin Eddie as the drug dealer, the go-between to these drug dealers, and that he was paying a lot of money and that he owed a lot of money. So the financial fraud and the drug addiction was ruled admissible at trial. That's what the judge said. But the judge said, I'm not going to let you bring in the roadside shooting, even though prosecutors argued hard to bring it in. Well, at trial, cross-examining the lead detective, the defense team started to do something that I've seen a lot as a trial attorney, as a prosecutor. I saw it a lot. The defense is trying to insinuate that there's alternate suspects and that they weren't investigated properly by police. And that's it's a very good way to go with the defense. But what they did is they started insinuating that Cousin Eddie could have been a suspect that wasn't investigated, and that Cousin Eddie's affiliates, these drug dealers, were suspects that could have been investigated but were not investigated. And I really saw it was amateur hour from the prosecutors, because they go on a break, and when they come back from break, immediately the prosecutor says, Judge, I need to bring something up. And the defense attorney's in the middle of cross-examination still. He's right in the middle of it. And the prosecutor says, I think they opened the door. I think they opened the door. We should get in that roadside shooting. And the judge sits back and says, well, you're not going to get into it right now. They're in the middle of cross-examination. Are you going to question this guy right now? And the prosecutor said, well, I just want to make a record. I think they've opened the door. I should be able to ask all these questions about the roadside shooting. And the judge again says, okay, but he's in the middle of cross-examination. Now's not the time. Prosecutor still, again, finally the judge said, I agree with you. Okay, and the courtroom kind of laughs. You know, there's probably attorneys in the courtroom too that are laughing at this big faux pas by the defense. But what I was looking at right there was, geez, man, this prosecutor is so amped up. They went on break. They were probably out there just giddy that they're going to get this piece of evidence in now that they wanted to get in. And they come back in and they jump the gun. And what I mean by that is this. When you go fishing, you don't start getting excited when the fish are nibbling around the bait. They're just nibbling at it, and you can see them. You're like, oh my God, they're nibbling the bait. They're nibbling the bait. And you start jerking your fishing pole out of the water. No, you let that hook get set in. You let them swallow the hook. And what they did is they came back in from that break, and they were just so hyped up to say they opened the door that basically what they did, this happens sometimes, is you were warning the defense. What if the defense had not fully opened the door at that point? And now you're giving them a heads up that they may be opening the door. I mean, what if the judge said, I don't think they quite opened the door, but if you go any further, defense, I'm going to say that door is open and they're going to drive a truck through it. I've seen that happen in trial before. What you do as a prosecutor is you sit back and you just wait. You wait, let him finish his cross-examination. Let him just keep going down this road. So they're lucky that they even got the ruling from the judge, because that's amateur hour by a prosecutor to come in and do that. And then the defense team looks so surprised, and they come in the next day, and the defense attorney says, well, I went back and watched myself on YouTube, and I only asked these questions, A, B, C, and D, and I don't see how that opens the door. And the judge says, well, you really cherry-picked the testimony from yesterday. You cherry-picked like 4 or 5 questions, and that's not what I was relying on. You brought into evidence. You brought up the issue of the relationship between Cousin Eddie and Alec Murdaugh, okay? And the roadside shooting sheds a lot of light on that issue of what their relationship is. And so if you're going to try and act like police didn't investigate Cousin Eddie because it was just their lapse that they focused the investigation on Alec Murdaugh and excluded suspects that they shouldn't have, that they should have done further investigation. Well, the prosecution is now entitled to get into the whole roadside shooting, because that's one of the reasons why police didn't investigate further into Cousin Eddie and this drug dealer gang, because they knew that Alec Murdaugh had a relationship with them at that point. They did investigate. And so, I've seen amateur hour on both sides of this. Trial work, you can step in it sometimes, but that's really 101. And the thing is, I see a lot of defense attorneys who do that. I'll give you a real big example. We file a motion to suppress, okay? Let's say police search your house. I'm representing you as a client. Police search your house, and they find drugs in your house. And then I file a motion to suppress what they found in your house. It was an unconstitutional search. And I win that motion. I win it. And the judge says, everything they found in the house, all the drugs, it's out of the trial. That's a big win for us. But we end up still going to trial. We don't get a plea deal. When we're at trial, I cannot now have that lead detective on the stand and say, well, you didn't find any drugs. I mean, there's no drugs being admitted here at trial. As signaling to the jury, like, they don't have this evidence. It's like, no, I just opened the door wide open. I can't put a fraud on the jury. I can't act like evidence doesn't exist that really does exist. So it's hard for a defense attorney to walk that line, as the judge in the Alec Murdaugh trial said, to dance through the fire without getting scalded or burned. Like, you really have to think that through before you get up there. And this was like not a very complicated one. Like, if you don't want to get into the roadside shooting, don't bring up anything or anybody associated with the roadside shooting. And definitely don't insinuate that the roadside shooter himself is the alternate suspect that must have been investigated, and try to plant that seed in the jury's mind that that guy could have done it.